When you have a music business question that you can't figure out, do what all the stars do. Ask Orville. Here is the star of the show, Orville Allman.
This is Orville. I'm with the law firm of Allman Law, PLLC. We have a question from a viewer today. The question is, what is typical in a music contract that a record label would have an artist sign? Well, that really varies from label to label. Although they all cover the same type of material, especially in today's digital world, you're going to find out that almost every label has a different type contract that has clauses in it that some other clauses aren't in other label contracts. And the definition in one contract may be totally different than the definition in another contract. But certain things that you're going to find out in almost all record labels that artists sign, they're going to want worldwide exclusivity, where they have at least your recording services, if not other services, for worldwide. They're going to have a recording commitment, where you're going to have to record so many tracks or so many sound recordings or so many albums or so many other type of recorded product during the term of that agreement. And most of them are going to be based on a period by period situation where you have to turn in either an album or so many recordings during each period. Then you're going to have recording procedures. How do these recordings get done? How do we select the producer? How do we select the songs? How do we select the studio? How do we decide how much money we're going to spend on the producer? How do we decide how much money we're going to spend on the recording itself? These are all type things that are normally worked out in the budget. A lot of times they're by mutual approval. A lot of times they're negotiated in the contract. Like you may have a producer that is pre-approved for the first album. The first album sells X amount of units, that he's pre-approved for the second album. That's one example. There may be budgets that you have X amount of dollars to make an album with, including the producer. Some of them includes the producer, some of them doesn't include the producer. Normally these type things are by mutual approval, but even when it comes down to mutual approval, if you have a disagreement among the record label and the artist, a lot of times in these contracts the record label has final control, but even if they don't have final control, it's going to be hard to get the record label to finance any record until that record is going to be recorded under the terms that they feel comfortable with, or that they've approved, or they feel that are satisfactory to them to get the type of product that they want. Other type things that you're going to find in these contracts are they're going to want you to pre-license to them songs that you have written, or at least the portion of the song you've written, to them at a certain rate that is lower than the rate that the U.S. government has put, what they call the compulsory rate, which right now is 9.25 cents for every mechanical or physical unit for every song on that record, which in most record contracts, if you wrote that song, they're going to want that song at less than that rate to put on there, and they're going to cap the number of songs on that record that they will pay you for. Normally being 10, 11, or 12 is where they're going to cap, even though the record may have 14 songs, which means that you're just going to get paid less for every song that you own that's on that record, or that your publisher owns that's on that record. And you've got to be careful, because if you signed a publishing deal before the record deal, the publisher controls the licensing of those songs. You don't control the licensing of those songs. So you need to get your publisher to approve the licensing provisions in that recording agreement to make sure that your publisher is okay with the licensing provisions in that recording agreement. Other things that you're going to find are accounting provisions. How often does the record company account to you? What audit rights do you have to make sure that they're accounting to you properly? There's normally going to be time limits set on that if you don't audit them within 2 years from the date they issue a statement to you, or 3 years from the date they issue a statement from you, that you've waived your audit rights, and those statements become final, which mean you can never object to them. And they're going to have limitations, that if you object to these statements, how long you have to sue them over these statements, which is normally going to be a year after the time you had to object to these statements. They're also going to have situations whether they're going to give you an advance for your recording plus a budget to record the record, or they're going to give you what they call a fund, which is an overall amount of money which you pay the producer, you pay for the recording of the record, and if there's anything left over after they've approved the record, after you've delivered it, and they don't send you back in the studio because they haven't accepted it, if there's any money left over, then that's what you get to keep. But you normally would get some portion of that as a signing advance, so you would be able to make some money when you sign that. All over since the digital age and the state of the industry as it is now, you know, those advances and funds and the cost of making a record, or the money that the most record companies are willing to spend to make a record, have gone drastically down in the last few years. So we've seen a downturn in the amount of money that they were spending on making sound recordings. They're also going to have in the contract what royalties you're going to get paid, how those royalties are computed, what they pay you for a top-line physical unit, what they pay you for a download, what they pay you for a record club, what they pay you for a mid-price unit, what they pay you for a greatest hits record, what they pay you for a ringtone, what they pay you for a ring back, all type of cyber uses for these sound recordings, what they pay you when they license one of your recordings for a motion picture, or for a television program, or for a commercial. All of these type things are going to be in your royalty provisions. You're also going to have to make certain warranties. You're going to have to warrant that you're free and clear. You're not signed to anybody else. You have the right to give this label, the exclusive rights to your recording services. You're going to have to warrant that when you turn in this record, that it's going to be free and clear from all claims from third parties. The costs have been paid, that you haven't incurred any costs that the record company hasn't agreed to pay. You're going to have to indemnify the record company, that if any claims are made against these masters, and the record company has to defend these claims, that any attorney fees that they end up paying to have to defend these claims, you're going to be on the hook for them. They can either demand that you pay them in cash to reimburse them, which would be one of these payback situations, or that they can elect to take that out of any other money that they owe you under the recording agreement, which could be royalties, could be advances, could be mechanical royalties, which really the money belongs, if you have a publisher, belongs to your publisher. Now they're going to have a hard time getting their hands on that money, but they do control it, although those rights don't really belong to you. But on the sound recordings, as far as the advances and the royalties, that money's come directly to you. Excuse me. But as far as the indemnification, if they bring a claim, even though the claim's not valid, unless it's negotiated in a certain way, which is not easy to do, which means it has to be a valid claim before you have to pay the record company back. Most of the contracts say if just a claim is made and they have to defend that claim, that you're responsible for the costs. And if they do a settlement, if they end up settling that claim, and you don't have approval of that settlement, or you don't have a limitation on the amount of money they can settle that claim for without your approval, then that money that they use to settle that claim also comes out of your money, or is a direct debt from you to the record company for the money that they paid for that claim. There's a lot of other boilerplate provisions that are going to be in these contracts, such as the state, where what state law is going to be used to determine the validity of these contracts. If you're going to sue each other over something, what state does that lawsuit has to be brought into? What notice provisions, how you serve notices on each other, whether you have courtesy copies to your lawyers, There's just all kinds of boilerplate. Some of these contracts are anywhere from 50 to 75 pages long. They're just something that an artist should not try to tackle alone. They need to have an experienced, competent entertainment lawyer look over these contracts, explain them to them, negotiate them, because these are very, very sophisticated and complex contracts, especially when you're dealing with majors. Most of the major independent labels also have very sophisticated contracts. And normally when you have a contract that has very few pages, most of the things are left out are the protections for the artist that are left out, and it's up to the artist's entertainment lawyer to make sure that those protections are put back in for the protection of the artist, because it's not up to the record company to protect the artist, it's up to the artist's lawyer to make sure that the artist is protected.
The material is for informational purposes only and does not in any way constitute legal advice or create an attorney-client relationship. The information contained in this website cannot and is not meant to replace the advice of competent legal counsel licensed in your state. To get your question answered, send an email to john@nashvilleninjamgt.com with questions for Orville, and visit the Ask Orville page on Facebook and leave your question on the wall.